Hi everyone, and thank you for joining us for our webinar today, where we will be learning about the new rulings. We will begin in approximately 1 or 2 minutes, so please just hold on for a minute. I see more people registering. We're going to give them a minute or two more to log in. Hi everyone, and thank you for joining us for our webinar today on the Department of Labor Fair Labor Standards Act. I am Joy Brand Richardson, and I'm coming to you today from JCC Association in New York. Thank you for taking the time to spend with us to join us on this webinar. I'm happy to welcome our presenter, Ellen Kearns, who is a partner at the law firm of Constangy, Brooks, Smith, and Prophete. Before we get started and I turn the controls over to Ellen, I want to do a couple of housekeeping notes. You will be muted by the system, but please don't put the phone call on hold or mute yourselves, because we may be able to hear your on-hold music if you have that. And I wanted to familiarize you with the dashboard on the right-hand side of your screen. You'll see an area where it says questions and chat. If you do have questions or concerns, I will be monitoring that, and you can type in your questions, and then I will be reading them off to our presenter later in the broadcast. There's also a raise your hand button that you might be able to see that we may be using at some point during the discussion. At the end of the webinar, there's a brief survey that will pop up on your screen after you log off. Please take a moment to fill out the survey and give us some important feedback. And don't forget to check our schedule of upcoming webinars. All of our webinars can be found on our calendar at jcca.org, and many have been archived on jcca.me. Now I'd like to present Ellen, who is the Editor-in-Chief of the American Bar Association Treatise, an extensive report on the Fair Labor Standards Act. Ellen is a partner at the Boston office of Constangy, Brooks, Smith, and Prophete. And Ellen will be addressing the provisions of the final rule and what JCCs and all employers need to be thinking about right now. We are also joined by Andy Eisenberg, who is a longtime friend and board member of JCC Association, also from the same firm, and works with Ellen, who will be giving us some insight as well. So thank you, Ellen, for joining us, and please take over.
Thank you, Joy. In May of 2016, the Department of Labor issued a new final rule that increased the salary level for exemption as a white-collar employee. But salary level alone does not make a white-collar employee exempt. Two other factors must be met. So based on the increase in the salary level and a review of those two other factors with Joy, we decided to make a presentation to you today that looks at all the factors necessary to be an exempt white-collar employee. Let's first review today's agenda. I'm going to give you a little background on the white-collar exemption regulations and how they came to be. I'm then going to talk about the salary level requirements, the salary basis requirements, and the duties requirements. Now to the background. The Fair Labor Standards Act was passed in 1938, and at its core, it requires two things. All employees should receive a minimum wage for all hours worked, and employees should receive overtime at time and a half for all hours worked over 40 in any single work week. Those two factors are the bulwark of the FLSA. But certain employees are exempt from the minimum wage and overtime requirements. Section 13A1 of the Fair Labor Standards Act provides an exemption from both minimum wage and overtime for any employee employed in a bona fide executive, administrative, or professional capacity, or in the capacity of an outside salesperson, as such terms are defined and delimited from time to time by regulations of the Secretary. Notice for a minute that this is Section 13A1. In order for the Fair Labor Standards Act to pass in 1938, there were in fact many 13A exemptions and 13B exemptions. 13A exempts employees from minimum wage and overtime, and 13B exempts employees from just overtime. Congress did not define the terms executive, administrative, professional, or outside salesperson. So, the Department of Labor in 1938, in the summer of 1938, looked at regulations defining those terms. These regulations, called the 541 regulations, cannot be set aside unless the Secretary exceeds his authority, or if the regulations are arbitrary, capricious, or an abuse of discretion. Let's think about that standard for a minute. Last week, a group of 21 states sued the Department of Labor because it said, these states' argument is that their new regulations are arbitrary, capricious, and an abuse of discretion. So we're going to go and look today at what these new regulations are, and then we'll come back and talk about the lawsuits filed by these 21 states. In order to be exempt, you have to meet three things. One, an employee must receive a certain minimum salary. Two, the exempt employee must be paid on a salary basis. As you will see, the term salary basis is different from the term minimum salary. Third, an exempt employee must meet certain tests regarding their job duties. So the first test, the exempt employee must receive a certain minimum salary. Salary levels, a level to be exempt, has been included as part of the exemption requirements since 1938. However, in 1938, only executives and administrators had to meet a salary requirement. The professionals did not have a salary requirement. There has never been a salary test for persons who perform the duties of an outside salesperson, a teacher, or an employee practicing in law or medicine, and business owners. Only computer professionals can be paid hourly, and that rate must be at least $27.63 an hour. Take a minute to just look at the salary levels that existed under the 541 regulations from 1938 to 2004. You can see, for example, that there were changes in the levels, and they didn't always have the same level. As a matter of fact, it wasn't until 1975 that the executive and the administrative actually had the same, and then the professional was 170. In 2014, President Obama asked the Department of Labor to propose revisions to the white-collar exemptions and to bring those exemptions and their requirements into the 21st century. In June of 2015, the Department of Labor, after conducting hearing sessions with various industry groups and employee groups around the country, came up with some draft regulations that required the standard minimum salary for exempt status to be increased to $50,440. It also increased the standard salary for a highly compensated employee from 100,000 to 122,000. In addition, it indexed these salary levels to a cost of living mechanism to be implemented annually. The regulations were out for the public's review and comment for 60 days. The DOL received almost 300,000 comments. And finally, in May of 2016, May 18, the DOL published its final rule. Let's see what the final rule says. First of all, the salary level was increased to $913 a week, or $47,476 annually. The highly compensated employees' annual compensation was increased to $134, and they allowed, for the very first time now, that the employer could count towards the $913 or towards the $47,476 non-discretionary bonuses and incentive payments up to 10% of the standard salary level. So here's what happened. The $913 per week is up from the current $455 per week, but it's down from the DOL's proposed $50,440. How did it get $913, you might ask? The Department of Labor looked at the list of all salaried employees in the United States, and then it looked at the salary levels in the various regions of the United States, and it took salary levels that were the lowest per region, and that was in the South, and it made a slice at 40%. So 47,476 is 40% of the salary levels in the United States. The 134,004 is up from the current 100,000, and it's also up from the proposed 122,000. And it reached the 134 based on more current data for highly compensated employees in the United States. How did it reach the 134? It made the slice on the list of salary levels, national list. It did not take a regional list. It took the national salary levels and it made a slice at 90%. And said that's the salary we'll use for highly compensated employees. With respect to bonuses and commissions, non-discretionary bonuses, incentive payments, and commissions can be paid at the quarterly level, and they can satisfy up to 10% of the minimum salary requirement. Let me show you how it works. So an employee makes $913 a week. Instead of paying that employee $913, you can pay the employee $821.70. At the end of the quarter, you multiply $821.70 times the weeks in the quarter, and if that total doesn't equal 1/4 of $47,476, when you add in whatever bonuses and commissions you paid him or her that quarter, then you make the sort of the true-up in the first paycheck of the next quarter. So if the compensation received does not meet $11,869 a quarter, first paycheck of the next quarter, you make up the difference. In addition, there are automatic increases that will go into effect every 3 years. The DOL dropped its requirement to make annual increases, and it now will make increases every 3 years. The first salary increase will occur on January 1, 2020. What should you do as a result of this final rule? First thing you have to do is to review all exempt employees whose salaries are below $47,476. Now, Joy gave me a list of the JCC professional staff averages, medians, minimums, and maximums. And the information was from 2014, so I'm going to presume that they were increased slightly in 2015 and maybe even this year. But as I look down that list, and I look just at the averages, the following positions are below 47,476. Accounting staff, marketing staff, membership staff, ECE assistant director, youth director, youth teen director, K-12 youth teen director, social worker, young adult director, other adult directors, fitness director, aquatics director, arts and culture staff, development staff, special events director, and administrative assistants in all departments. So all of those employees, at least on average, are making less than the salary requirement for exempt status. So you should do the same thing. Go down your staff, go down your list of people that you believe to be exempt, and for all those that are below 47,476, you have to decide. Should I reclassify them as non-exempt, or should I increase their pay to pay them $47,476? In addition, you need to calculate how you're going to compensate them for overtime. So this is your decision that you have to make between now and December 1. Should you raise their salary or reclassify them? If you decide to reclassify them, should you classify them as salary non-exempt or hourly? Here are some things to consider. Do your benefit packages make a difference based on exempt status? So will it impact someone's benefits, vacation, PTO accrual, or bonuses if they're exempt or non-exempt? A second factor, employees like to be considered exempt. Even though they don't get overtime, employees like the halo effect of exempt status, and they feel less valued if you don't classify them as exempt. Another factor to consider is how much does it cost you to increase the salary? Remember that any salary below $43,160 will have to be raised at least 10%, and every 3 years thereafter, the salary will have to be raised again. Compare that cost to the cost of overtime. If you know that some of the positions that I just referred to regularly work overtime, then you should take the weekly salary of those employees, divide by 40, multiply by 1.5 times the expected overtime hours, and compare the overtime cost to the cost of increasing a salary. Now there is a cost-neutral solution that you could go to if you wanted to. If you have a good estimate of the expected weekly hours worked, you could apply the formula that I've laid out on this slide to provide an hourly rate which will result in the same weekly and annual compensation. This formula has been approved by the Department of Labor. And I'm going to show you how it works, but I want to caution you that this means lowering an employee's hourly rate, and many employees will not be happy with that. So let's assume an employee makes $800 a week and they regularly work 10 hours of overtime. Applying the formula, you take 800 and you divide it by 40 plus the overtime hours worked, which is 10 times 1.5. So 40 plus 15 is 55. You divide 55 into 800, and you come up with an hourly rate of $14.55. So instead of having this person make an hourly rate of $20, you lower their hourly rate to $14.55, and as you can see, $14.55 times 40 hours is $582. $14.55 times 1.5 times 10 is $218.25. Adding them together, the employee makes just about $800, $800.25. So this is a cost-neutral way of having the employee have the same dollars in his pocket at the end of the week, but his or her hourly rate is significantly lower. How do you determine an overtime rate for a previously exempt employee? Do you divide that employee's weekly salary by 40, or do you use the fluctuating work week method? Suppose, for example, the employee makes $800 a week and that they regularly work 50 hours. To determine the overtime rate, you can say, well, that $800 was for 40 hours, so I need to divide the 800 by 40 and I get $20 an hour. Now I multiply 20 times 1.5 times 10 overtime hours, and the individual will get $300 for the overtime worked. Therefore, their paycheck at the end of that week will be $800 for 40 hours, $300 for overtime, or $1,100. There is a second way of calculating overtime, and it's called using the fluctuating work week. Again, assume the employee worked for $800 a week, and that they worked 50 hours. Under a fluctuating work week analysis, you assume that the $800 was for all hours worked in the work week. So you take $800 and you divide it by 50. That's all hours that person worked that week. And you get 16. But instead of multiplying 16 times 1.5, you only multiply it by 1/2. 16 times 1/2 is 8, times 10 overtime hours is 80. So as you can see, using the fluctuating work week method is a lot less costly to an employer to pay for overtime hours. And you're probably saying, yeah, what's the catch? What's the catch? Well, here's the catch. In order to use the fluctuating work week method of paying overtime, there has to be a clear mutual understanding between the employer and the employee that the fixed salary he or she is receiving is compensation for all hours worked each work week, whatever their number, rather than for working 40 hours. There's no requirement that this understanding be in writing, but as an attorney, I recommend it as best practice. Now, there's a couple of other things to keep in mind. The DOL enforcement position is that if you're using the fluctuating work week method to calculate overtime, you cannot pay them any other compensation. So you can't pay them any bonuses, you can't pay them any commissions, you can't pay them any kind of salary or payment except for the salary you're using to calculate overtime on a fluctuating work week method. Secondly, you cannot prorate their weekly salary. So, for example, if an employee doesn't show up on Monday, they still get their weekly pay. You can't prorate it based on how many hours they work, less than 40. And finally, you should check state law, because some states, for example, California, does not permit the fluctuating work week method of calculating overtime. New York also has some serious reservations about the fluctuating work week method of calculating overtime. So now what do you do? New rule, it's going to go into effect December 1. What am I recommending that you do? Well, I think you have another problem, which is it's possible that some of the people you have classified as exempt don't really meet the duties test. And we're going to spend a few minutes today going over the duties test, but you could use this time, the next month or month and a half, to review the job descriptions and the performance evaluations and the training materials given to these workers that you're calling exempt to be sure that they meet the duties test. Because it would be foolish to raise their salary all the way up to $47,600 if in fact their duties didn't meet the duties test. I would also consider interviewing some senior managers to determine what in fact they do, and I recommend that you conduct some kind of a legal analysis to determine if the job duties qualify for exemption. Remember, to be exempt, the salary has to be $47,600 or $913 a week, and the employee has to meet the duties test. Once you make a decision whether you're going to reclassify somebody or raise their salary, you need to decide who's going to tell the employee about their classification, how will the decision be communicated to the upper management, who's going to communicate it, what are you going to tell the workers, and how will the communications be effective? Will you put it in writing, meet them as a group, etc.? Then you should decide when will the changes be communicated. Remember, they have to be communicated by December 1. There's nothing to say you couldn't do it in the middle of November. I recommend you prepare talking points and FAQs to explain to employees what you're doing. Finally, some state laws require advance notice to employees of changes in their pay. The most common is 7 days. Missouri requires 30 days notice, and other states require notice only when you're going to reduce somebody's pay. So keep this in mind when deciding when to inform people about their change in exempt status. Finally, I'd like to point out that if you're going to reclassify exempt employees as non-exempt, one of the things you have to concentrate on is making sure that these newly reclassified employees know that they have to keep track of the hours they work. These employees are not used to clocking in and out. They may not record their time at all. And the particular problem areas are work performed by employees before and after work performed by employees during a lunch period, or work performed at home. Remember, non-exempt employees have to be paid for all compensable work. Communicate the change with managers, prepare talking points, and then train the reclassified employees in timekeeping procedures. New rules are not going away. You need to do some work between now and December 1 to determine the exempt and non-exempt status of individuals who fall below the $47,600, and you need to decide how you're going to pay these reclassified employees for overtime. December 1 will be here sooner than you think. All right. Now let's talk about the two other standards for meeting exempt status. The first is that employees have to be paid on a salary basis. That is, week in and week out, they make a predetermined salary on a weekly or less frequent basis. You can't reduce that salary because they worked less that week or because you didn't like the way they did the work. Subject to the exceptions I'm going to describe in a minute, an exempt employee has to receive his or her full salary for any week in which the employee performs any work. The predetermined amount is a fixed amount. You can't keep changing it week to week, and it has to be fixed for an indeterminate number of pay periods. An employee does not need to be paid for any work week in which they perform no work. And salary basis or salary status is not defeated because you pay an employee extra time or because you require them to punch a time clock. So additional compensation paid on any basis beyond the guaranteed salary of $913 does not change the salary basis rules. Here's what you can deduct from the salary of an exempt employee. Absences of 1 or more full days taken by the employee for personal reasons. Absences of 1 or more full days taken when an employee is sick or disabled if the deductions are in accordance with a bona fide plan providing compensation for salary lost due to illness and the employee has run out of sick days. And you can deduct fees that an employee receives for jury duty or for military pay. You can also deduct from a salary of an exempt worker for any, let's say you gave them a 3-day suspension because they violated safety rules of major significance. Or you say you gave them a 2-day suspension for violating the sexual harassment policies. Unpaid disciplinary suspensions for 1 or more full days that are imposed in good faith for workplace conduct infractions. The key here is that the infraction has to be known to the worker, has to be posted somewhere, or can be an employee manual. And finally, the employer is not required to pay the full salary of an employee during the first week of their work week and during the last week of their work week. So, for example, an employee comes in on Wednesday and works Wednesday, Thursday, Friday, you do not have to pay that employee for Monday and Tuesday. The same thing occurs during the last week of employment. Here's what you can't deduct from exempt employee salary. Partial day deductions. Employee takes 2 hours off to go and see his son's soccer game. The only exception to the partial day reductions is that you are permitted to make partial day reductions for FMLA reasons. You cannot deduct if the employer needs to shut down due to any outside force, such as a hurricane, a snowstorm, or whatever. If you close, then the worker still gets their pay for that day. If the employee has exhausted all his or her sick leave account and is in a negative balance, you cannot deduct the negative balance from that employee's paycheck. Most of your employees are paid on a salary, so I'm not going to spend any time today on the fee basis alternative. So presume that your salary level is okay. Presume that the employees are paid on a salary basis. The next thing to check is to be sure that your exempt employees meet the duties test. There are, as I say, 4 categories of exempt work. It's executive, administrative, professional, and outside sales. We're going to emphasize today the executive, the administrative, and the professional. Joy tells me that very few of you have computer persons, so we won't spend hardly any time on that, and I don't believe you have outside sales. The executive. The primary duty of an executive must be managing the enterprise or a customarily recognized department of the enterprise. Secondly, they have to customarily and regularly direct the work of 2 or more other employees. And finally, the executive has to have the authority to hire and fire other employees. And if he does not have the authority to hire and fire, he must have the authority to make suggestions and recommendations that are given particular weight as to the hiring, the firing, the advancement, the promotions, or any other change of status of employees. So as you can see, the test for executive exemption under the Department of Labor regulations doesn't care at all about whether the business is successful or whether or not you grow the business or don't grow the business. It cares about whether or not you manage the workers who are assigned to you. Here are some of the duties that constitute management duties. Do you interview, select, and train employees? Do you set and or adjust their rates of pay? Do you direct their work activities? The next 2 probably aren't applicable in your business, but do you handle employee complaints and grievances? Do you discipline employees? Do you plan the work of employees? And do you decide what techniques will be used? And then some of these others we could skip. And do you provide for the safety and the security of the employee? Do you plan and control a budget? And do you monitor or implement legal compliance measures? So when you're reviewing your workers to determine whether or not they might be exempt, if you believe a director meets the executive exemption, go down to this list of management duties and check off the ones that you believe apply. Now, employees who spend 50% or more of their time on exempt work, and exempt work again is those previous two slides we just looked at, will generally satisfy the primary duty test. But when employees spend less than 50% of their time performing exempt work, the following factors are applied to determine if management is really their primary duty. Before I change the slide, think of it in the fast food context. The question has arisen as to whether an assistant manager at a Burger King would meet the duties test for exempt status. The assistant manager at a Burger King is probably serving the customer. She may even assist with cooking the meals if necessary. She may assist with sweeping the floor if nobody else is around. So clearly that manager doesn't spend more than 50% of his or her time on exempt work. So how do I know if they're exempt? So what you look at is the importance of the exempt duties compared with other types of duties. The amount of time spent, and I can tell you after having looked at many, many cases on exemptions, if the amount of time spent on exempt work is less than 20%, the court is not going to be happy with that low percent on exempt status, on exempt work. Thirdly, you look at how free from supervision is the employee in performing the exempt work. Are they all by themselves, or do they have a supervisor 50 feet away? And finally, the court looks at the salary of the exempt worker and compares it to the salaries or the hourly rates of the non-exempt workers that they're supervising. So these four factors would come into play if the worker spends less than 50% of his or her time on exempt work. What is a customarily recognized department or subdivision? According to the regulations, it's a unit with a permanent status and function. So it's not a bunch of people that picks up in the morning and goes out and does a task. It has to have a permanent status, and it has to have a permanent function. Employees who are in charge of shifts or who head a team with a defined membership will meet the requirement. And you should know that the department or the subdivision does not need to be physically located within the employer's establishment. It may move from place to place as long as it has some kind of permanent status and function. Direct the work of 2 or more employees. According to the regulations, this standard means that you must normally and recurrently perform this direction every work week. It can't be once or twice a month. It has to be every work week. You are normally and recurrently performing the direction of 2 or more employees' work. Now, you are not required to have 2 full-time employees. You could have 4 half-time employees or 6 employees even if the sum of the hours worked of those employees equaled 80. So you can supervise 2 or more employees in the absence of a manager, but that doesn't count for exempt work. It has to be your job to direct 2 or more employees for 80 hours. Now, what does it mean to have authority with respect to personnel matter? Well, the exempt employee has to be involved in the hiring, has to be involved in the firing, has to be involved in failing to promote, reassign with significantly different responsibilities, or has to be involved in a decision causing a significant change in benefits. You don't have to make the final decision, but you have to be involved in those decisions regarding the employees over whom you give direction. How do I know if my recommendations are given particular weight? Well, you look at the job description. Is it part of the employee's job to make such suggestions and recommendations? How frequently does management or HR ask the employee about hiring, firing, and change in status? How frequently does HR or senior managers rely on your recommendations? Some of the lawsuits that have come up regarding the executive exemption have listened to witness testimony that recommendations were made and considered, have looked at a job description that specifically lists the requirements to hire or fire or recommend change. The courts have looked at performance reviews where the person giving a review documents the employee's activities with respect to hiring and firing and recommending change in status. And any other documents that exist regarding promotions, demotions, or other change in status. Do you want to say something, Joy, about the question?
Do you want people to ask questions now, or do you want to keep going and then ask questions at the end?
I guess I'll keep going unless somebody out there has a question now about the executive exemption.
I think the term executive exemption, when people are first hearing it, they're thinking of only the executive director. And I think what we're talking about in terms of JCCs are senior level staff, people who fall into that category whose title might not have the word executive in it.
In my view, looking at your list of jobs, any person who has the title director is potentially exempt, depending upon if they supervise enough people and whether they have the authority to hire and fire. So a director without any direct reports clearly would not meet the executive exemption, but directors who have direct reports might, again, as we just went through the test. Okay, I'll keep going and then we'll come back.
Good idea.
Okay, the administrative exemption. The test for, it says executive, but it should be administrative exemption is that the primary duty of performing office or non-manual work directly related to management or general business operations of the employer or the employer's customer. The primary duty has to include the exercise of discretion and independent judgment with respect to matters of significance. So let me go back again. Office or non-manual work. The test is in this disjunction. So either office work or non-manual work will satisfy this requirement. If the worker performs some manual work that's directly and closely related to the work that requires the exercise of discretion, that will not necessarily defeat exempt status, unless the amount of time spent on manual tasks is substantial. So when you're looking at titles like the Director of Maintenance or the Director of perhaps aquatics, etc., if the person performs non-manual work a significant or substantial amount of time, they won't meet this office on non-manual work requirement. Work must be directly related to assisting with or running or servicing the business, as distinguished from working on a manufacturing or production line or selling a product. Now those two distinguishing characteristics don't really apply to JCC jobs. I think the easiest way to compare assisting with running or servicing of the business against production work is in the job title of investigator. So Macy's, for example, could hire an investigator to assist them with theft that might be going on in the stores. And they may suspect somebody of using a fraudulent credit card or going into the ladies' room and changing and walking out with their clothing. The investigative work performed by the investigator would be servicing the business of Macy's. Compare that to an investigator who works for the ABC detective agency, and their job is to determine whether or not there is fraud going on at a particular location, or their job is to find out whether or not a husband or a wife may be unfaithful to their spouse. That investigative activity is the precise product that the detective agency is hired to do. So they're being an investigator, they're going out and investigating, but they're not going to be an administrative exempt employee because they're not servicing the business of the detective agency, they're doing the work of the detective agency. Keeping that in mind, these are the kinds of duties or the kinds of responsibilities that persons engage in when they are servicing a business. Engaging in tax, accounting, auditing, quality control, procurement, marketing, safety and health, HR, labor relations, computer network, internet and database administration, legal and regulatory compliance, finance, budgeting, insurance, purchasing, advertising, research, personnel management, employee benefits, and government relations. These would be areas that are engaged in servicing the business and not producing the product of the business. Essentially, the administrative person is distinguished between the employees who are engaged in running the business and not merely the day-to-day carrying out of its affairs. It involves the comparison and the evaluation of possible courses of conduct. And a person who's an exempt administrator has to make decisions after various possibilities have been considered. It implies that the employee has the authority to make an independent choice, free from immediate direction and supervision, even if the choice of the administrator is subject to review at a higher level. So as long as the administrator is told, you decide what we're going to buy here, or you decide what tasks we're going to engage in, or you decide what person we're going to hire, whatever administrative task has been assigned, that they make a decision, even if the president of the company has a chance to review that choice and overturn it. Mere use of skill in applying well-established techniques, procedures, or specific standards described in manuals or other sources will not satisfy the discretion and independent judgment requirement. And this would apply to individuals who essentially do their job by referring regularly to either manuals or how-to kits, or where you have specific rules that have to be followed, and all the administrator does is to follow these in the doing of his or her job. The administrator's work has to be important and has to have a consequence to it. It does not mean that the employee's failure to perform certain duties will cause the employer to experience financial losses. The Department of Labor, when it put that standard out there, it said, just because a runner runs a $500,000 check from the business to the bank and loses the check, thereby causing the employer to experience a financial loss, doesn't mean that the runner is an exempt administrator. I'll come back later for other questions you may have regarding the administrative exemption. I can say this, after 40 years of dealing with this exemption, it's the most difficult to understand, it's the most difficult to apply, and it's the one that's litigated the most often. The professional exemption. There are 4 types of professionals: learned professionals, creative professionals, teachers, and employees engaged in the practice of law or medicine. The learned professional. That's a person whose work requires advanced knowledge in a field of science or learning, and that knowledge is acquired by a prolonged course of specialized intellectual instruction. What does advanced knowledge mean? It's predominantly intellectual in character. It entails the consistent exercise of discretion and judgment, and the advanced knowledge cannot be attained at the high school level. So as you go through the persons who work for you or the persons in your JCC, and you classify somebody as a learned professional, make sure that they have a degree. In a field of science or learning, there are occupations with recognized professional status that are distinguished from the mechanical arts or the skilled trades. Examples of fields of science include law, medicine, theology, accounting, actuarial computation, engineering, architecture, teaching, physical, chemical, or biological science, and pharmacy. As you notice, many of these examples are not found on the JCC list of professionals that I was given, except for the teaching. We're going to spend a little time in the future on teaching. What does it mean to customarily acquire the knowledge by a prolonged course of specialized intellectual instruction? There are 2 ways of getting specialized intellectual instruction. According to the regulations, specialized academic training is a standard prerequisite for entrance into the profession. But the regulations also provide that the learned professional exemption is available to employees who have substantially the same knowledge level and perform substantially the same work as degreed employees, but who attain the advanced knowledge through a combination of work experience and intellectual instruction. So you can't learn everything on the job, and if you're a non-degreed worker who is going to be classified as an exempt learned professional, you have to have some intellectual instruction. And we recommend, as lawyers, that the safest way to classify a learned professional is to be sure that he or she has a degree. Here are some titles that the regulations provide are exempt: medical technologists, nurses, dental hygienists, physician's assistant, accountant, chefs, athletic trainers, paralegals, and other occupations that are certified. Accountants generally meet the duties requirement. However, bookkeepers, accounting clerks, and those persons who work with numbers but don't have discretion and independent judgment will not meet the learned professional standard. Creative professionals. The primary duty requires invention, imagination, originality, or talent in some recognized field of artistic or creative endeavor. The fields of artistic or creative endeavor include music, writing, acting, and the graphic arts. Exempt duties do not include work that can be produced by a person with only a general manual or intellectual ability. Journalists vary along a spectrum from exempt to non-exempt. Essentially, a writer of a newspaper who is just performing just telling the public what happened at an event and not putting forth his or her opinion regarding what happened at an event is not an exempt creative professional. You have to put something out there that's new, that's different, that you thought of in order to be an exempt creative professional. Teachers. The primary duty of a teacher must be teaching, tutoring, instructing, or lecturing in the activity of imparting knowledge. And they must be employed and engaged in this activity as a teacher in an educational establishment. When the final rule came out in May of 2016, the Department of Labor knew that certain industries were going to be affected by the new rule, and one of those industries was colleges and universities. So it issued what is called guidance for higher education institutions on paying overtime under the Fair Labor Standards Act. And in particular, for JCC purposes, the guidance talked about athletic coaches. And it said that athletic coaches hired by higher education institutions may qualify for the teacher exemption. And that it said the teaching may include instructing student athletes in how to perform their sports. However, if the coach's primary duties are recruiting students to play sports or visiting high schools and athletic camps to conduct student interviews, they are not considered teachers. So one of the requirements that you can be thinking about as you look at your job descriptions are, does this person engage in teaching? If the answer is yes, then they don't need to meet the 47.6 requirement. There is no salary requirement for teachers. Here is a list of some teachers that have been found to meet the requirements for exempt status. Preschool teachers, teachers of kindergarten, teachers of gifted or disabled children, teachers of skilled and semi-skilled trades or occupations, teachers engaged in automobile driving instruction, aircraft flight instructors, and vocal or instrumental music instructors. And many of you have coaches or teachers that would meet the teaching requirement and don't have to be paid any minimum salary. I'm going to skip over law and medicine because I don't think you have those employees. The highly compensated employees. I looked at your list of employees, and you do have some employees at the higher level that meet the salary requirement. The salary requirement is $134,004, but that person must make as a minimum $913 a week, and the rest of their pay can be in commissions, bonuses, payments, non-discretionary payments. It does not include fringe benefits or board and lodging. Primary duty must include office or non-manual work, and they must customarily and regularly perform at least one, of the exempt functions of an executive, administrator, or professional. The computer employee I'm going to skip over. Joy told me that I didn't have to worry about that. So let me summarize what I've said today. The executive employee must receive a certain minimum salary. That minimum salary is $47,476. And the argument of the various groups that have filed lawsuits against the Department of Labor regarding these regulations is that by making the salary double what it was before, you have this means that there are persons out there who are actually performing exempt work. They meet the requirements of the executive or the administrator or the professional work. But because they don't make $47,476, you're qualifying them as non-exempt. And that's against the intent of the law that exempt work should be exempt. Secondly, an exempt employee must be paid on a salary basis. And finally, the exempt employee must meet certain job duties. Those are the three requirements for exempt status. And what am I saying to all of you with all of this as your background? One, go back and check and see how many workers that you currently classify exempt aren't making the salary. Two, if you have workers who are making the $47,476, but you don't think they're going to make the duties test, take this opportunity to review those workers, review those job requirements, and reclassify them. Because many people will be reclassifying workers, and you will have less of a chance that the worker will say, wait a minute, I've been doing this job for 3 years. Maybe I should get overtime. Maybe I wasn't properly classified before. And that's true. That they could say that. But we are finding that most workers like the idea of getting overtime, and they'll be just happy to take the overtime and move forward. Joy, you want to start off with any questions?
Yes. Well, first of all, thank you, Ellen. I think this is head-spinning and exciting and frustrating and all those things all put together, and I think it's wonderful that we're able to provide this information for the people on our webinar and keep this as a recording so that people can refer back to it. If you have a question, you can type it into the questions bar, and I will read out some of them. I did get one or two as you were speaking. On some of the areas that we didn't touch on, Ellen, you and I and Andy had talked about summer camp staff. And there was a question about, what about summer camp staff who are always working many more than 40 hours a week? Let's not even talk about overnight camp staff. Let's just talk about day camp staff who work more than the 40 hours, who may not be considered exempt. What do you think about that?
Well, I'm glad you asked about that. And the reason I didn't discuss it is that day camp persons, to be exempt, don't fall within the white-collar exemptions. That's a separate exemption. That's what's called the 13A3 exemption, and it provides an exemption for employees who are employed by an organized camp or a nonprofit educational camp if the camp does not operate for more than 7 months in any calendar year, or if during the preceding calendar year its average receipts for any 6 months were not more than 33 1/3% of its average receipts for the other 6 months. So the seasonal exemption just relies on how long are you operating, and during the period in which you operate, are you making a lot more of your money? That's the time in which you make your money, as opposed to the rest of the year. So I could do a different seminar. I just didn't want to confuse people because it's a different exemption with different requirements, but the requirements are basically how long do you operate, and the time in which you operate, does that consist of most of the income for the employer. Right. Okay. So I'm just saying that if you operate for 6 months or less, you're safe. If you operate for more than 6 months, it has to be the 33 1/3% test. Okay. Here's another question. It doesn't matter then if people work overtime. It's an exemption for minimum wage and overtime. And it seems like it's also based on whether the camp operates just for a few months or it's a seasonal. That's correct. Classifications, we have to look into 13A3, so thanks for that. 13A3, right. Just look at 13A3 and that's the test. Here's the exact language says, as long as the camp does not operate for more than 7 months in any calendar year, or, so it's an or, during the preceding calendar year, its average receipts for any 6 months of such year or not more than 33 1/3% of the average receipts for the other 6 months.
Okay. And then in that case, those camp staff,
they can work as much as you require. Correct.
okay. Here's another question. What salary is the minimum that determines a highly compensated executive? So we have some department heads who are at $70,000 or $80,000. What makes them get bumped up to the $134,004?
If their W-2 income at the end of a calendar year is $134,000 or more, they can have a salary of $70,000, and everything else can be in bonuses and commissions and whatever. The only thing that has to happen is that they must receive each week $913. So as long as they make $913 a week, at the end of the year you can do what's called a true-up. And you can, but here's the risk. If there's a risk that they won't make the $134, then you have to go back and pay them the overtime if they didn't make the $47,6.
So how do you determine who falls in that category of the higher? Highly
compensated employees have 2 requirements. 1, $134. 2, they only have to meet one of the tests of the executive exemption, or one of the tests of the administrative exemption. So, for example, the administrative exemption has 2 tests. One is, do they perform work servicing the business? And then 2, do they exercise discretion and independent judgment? So if they're not exercising discretion and independent judgment, but they're servicing the business, as long as they're making $134,000, they would be exempt.
Okay. I think that's something that offline maybe I'll be speaking with you about. We can send out a more complete list of who might be falling in those categories.
Okay.
Okay, I have another question here that is, we have people called program directors who are currently class exempt, who travel with program participants and work 40 hours plus for a short period of the year, as an example of taking kids on holiday trips or the JCC Maccabi games when they're full-time during the year, and then they work an extended trip. So what part of that, do they average their salary and then pay them that in a weekly salary, or do they require to pay overtime for that period of time?
So the exempt status of a program director would be determined by their primary duty. And if part of their primary duty it includes these games, attendance at those games and being with the children at those games, they don't lose their exempt status necessarily just because the way they perform their job during those weeks is different, providing they make $913 a week every single week. So if you're telling me that the program director makes at least $47,000, and you're telling me that they make at least $913 a week, and you're telling me that primary duty includes 2 to 3 weeks of attending these games, that doesn't change their exempt status. I'm not sure if I answered the question, but maybe you could reword it. Or
you answered the question, but however, if they're making less than, as
okay, well that's a different question. Okay, that's a different question. If they're making less than $47,000, then they're not exempt. And the question then comes up, how do I pay non-exempt employees for time spent in travel as part of their job? Right? Is that the question now? All right.
Yes.
So paying for travel is covered in the regulations. I didn't cover it today, so you didn't miss it. But paying for travel time is not easy to discern, but I can tell you this. Travel to and from work is essentially commuting time. But if the travel is what we call overnight travel, so you're going to another city, you're going to a different location in which you're going to stay overnight, then all the travel that occurs during that employee's regular work day. So if the employee would regularly work 9 to 5, and they travel during the 9 to 5 period, then all that's paid. If they travel outside of their normal workday, so nobody gets in the car and travels until like 6 o'clock, 6 p.m., travel does not have to be paid for. So for non-exempt workers, travel outside of the regular workday does not have to be compensated.
Okay. And then once they travel to this place and they stay there for an entire week, sleeping in a hotel and doing work.
Well, now we're getting a little complicated. I really would. Maybe we could do this offline, and you can send around a note, because this is compensation. This is a different issue, and the issue is compensation of non-exempt employees for travel time.
Yep. Okay. We will do that, and for the listeners, I will work with Ellen and her staff, and we'll get some information out on that.
And it's not that I don't know it, it's just that it's complicated, and there's a lot of ifs, ands, and buts.
I understand that. Let's see. There's another question about the early childhood teachers, if you don't mind going back to that they must spend at least 50% or more of time actually teaching. Can we claim that our 2-year-old teachers are actually teaching, or are they just child care providers?
That's a great question. I thought that might come up. So it's not exactly as you've just regurgitated it. Teachers, remember, don't have a salary requirement. So it's important to get as many people into that teacher category as you can, because there's no requirement to pay them $47,6. There has been a lot of litigation about teachers, and the litigation is that if their responsibility is to teach as opposed to babysit, that's the key. Are they actually teaching these children? Are they providing information? The language is, are they instructing, lecturing, tutoring, imparting knowledge in some way? Okay, imparting knowledge, I realize we have 2-year-olds here, but if it's really just watching out for them and there's no teaching going on, they're not going to make the teaching exemption. But if they are imparting knowledge, that's their primary duty, to impart knowledge. In addition to that, they have to make sure they do other things, like sit down and eat, etc., and sleep. Their primary duty is to impart knowledge, then they will be considered an exempt teacher. And there's a case called Reich versus Miss Paula's Daycare, in which the daycare offered preschool education in addition to caring for the children, because some of them were young. So the key, I would just say, the key to JCC's exemption of teachers is to be sure in all of your JCC preschool programs you have education as a component.
That's a great way to get around that, and certainly as we rewrite job descriptions, certainly I would think from the programs that I've seen, our early childhood staff, even in infants and toddlers, are teaching. They're, and if we include it in their job description, I think that's a great way to.
Right. Right. I mean, if their primary duty, keep using that. If the primary duty is to impart knowledge, I know that's lawyer words, but say the same thing in JCC words, that's going to make you exempt.
Yeah, that makes sense. What about someone's weekly work schedule that fluctuates? So some people work Sunday to Thursday one week, and then they work Monday to Friday, and they might come in, you know, and do some nighttime. They might work 1 to 10 on one day, and the next week, that same day, they work 9 to 5. You know, how does that work?
Well, first of all, that type of person, it sounds like, is non-exempt. Would I be wrong in making that assumption?
You might be wrong.
Because it doesn't. Because if they're exempt, it doesn't matter. They can work 168 hours. That's the key. If you are exempt, I don't care how many hours you work. I don't care what schedule you work. I don't care if you require me to work Sundays, Thursdays. Doesn't matter. But you've got to be sure that they're exempt. So if they're non-exempt, then we got another problem. And the problem is this. Non-exempt employees can be required to work Sunday to Thursday, Monday to Friday, whatever, but some states require that you pay time and a half for working on Sundays, and you pay time and a half for working on holidays. So it's a state issue. It's not a Fair Labor Standards Act issue. All the Fair Labor Standards Act requires is, for non-exempts now, is that you pay minimum wage and time and a half for overtime. and that you have to set the week up. You can't keep switching the week. So you set a week up as Sunday to Sunday, and that's the period in which you look at how many hours does the worker work. So from midnight on Sunday to midnight the following Saturday, how many hours did that employee work? If they worked more than 40, you get the hours over 40 at time and a half.
Great. Okay, that makes sense. Let me just look down here and see if there's any others. Somebody says, can I assume that an executive director making over 100,000 is highly compensated?
No, you cannot. It has to be 134.
Okay. We do have some executive directors who are not making $134,000.
That's okay. They might meet the requirement anyway for 47.6. You don't have to make the one. The only reason we have this 134 is if you're not doing exempt work, and that's not your primary duty. So it would be hard for me to believe that an executive director didn't have the authority to direct at least 2 or more employees for 40 hours. But if they didn't, then they would have to have one other requirement. Maybe they were in charge of a customized division or subdivision. It seems to be they're in charge of the whole place, right? So the only advantage to the highly compensated is I don't have to meet all the tests. I just have to meet one of them.
Right. But
if you meet all the tests and be paid 47.6 or above, you're going to be exempt.
Great. I think we might have covered almost all. I saw a couple of questions that were sort of repeats, so I didn't ask them twice. Let's see. There was another question about camp. And I know that you and I have talked about this, about camp that uses campgrounds that are specifically only used for campgrounds and camps that are considered part of the JCC building. And many times, camps who run in the summertime when school is out also call things during holiday time as camp. And so they could be considered running year-round camp, even if they only have a week of camp during Thanksgiving week and a week of camp during Christmas week, things like that.
Mm-hmm. So, well, you know, it's not so much the camp. I'm more interested in the worker. What is the title of the worker who's doing this?
In many cases, it could be the youth director, it could be the teen director, it could be the camp director, or it could be any number of people under those people. They don't necessarily have to be the department heads who might be exempt. It could be some of the people who you read off of that list who are making less than $47,476.
Right, and so they're not exempt. I saw a title called camp director. It's unlikely that they're going to be exempt on a salary basis. Could they be teachers? Are they teaching these children?
I think there again, JCCs professionals who are listening, I think that we take that into consideration when we write the job descriptions. And so if you're running winter camp and your staff person who's not making $47,476 is running winter camp and therefore working lots of extra overtime and you're calling it camp, that we have to think of what is a teaching experience that they may be doing during that time, or are they just taking the kids to the movies and to bowling? I think it's part of the job description and how we write it.
Right.
Well, Ellen, thank you.
I mean, these are questions that I would have to think about a little bit longer if you wanted me to, but I'm just saying that I don't think a camp that doesn't go for 6 months, this is just a 1-week camp or 2-week camp, and the rest of the time they're working in an operation that clearly it's not 1/3 of their income, in other words, the 1-week camp.
Yeah.
So,
all right, so,
I mean,
go ahead. Ellen, you still there?
I'm still here, yes?
Okay. All right, so I'm going to say thank you very much to you and to Andy for setting this up. This has been a very wonderful way for us to get our ducks in a row and start thinking about who are on our staff and who we have to take a look at their status and maybe reclassify. JCC Association is going to work with Ellen and her firm on providing more information, as well as if you have questions that you would like to work directly with Ellen and her firm, please contact me and I will put you in touch with them. They have graciously offered to help you on the legal side of things at a reduced rate, which were because of your affiliation with JCC Association. So please do contact me and I can put you in touch with them as well. And I hope that everybody on the call and everybody who will be listening to this as a recording will really start to take this seriously and think about December 1st being only a couple of months away. And let's work together and share this on the HR listserv and through the executive listserv about what you're doing and the successes you're finding and how you're having conversations with your staff about if you're reclassifying them, how are you dealing with reclassification and things like that. And certainly from JCC Association, we will push out as much information as we can on this very important subject. So thank you very much, everyone, for being on our webinar, and thank you again to Ellen and Andy. We really appreciate it.
No problem. Thank you.
Thanks very much.